as Mr. Lantigua, he was removed from the driver's side upon the end of the pursuit, but the first operator was identified as Mr. Nieves before they swapped. A license plate that was attached to the vehicle was listed as a stolen plate on August 22nd of this year to a female party out of Methuen. An inventory of that motor vehicle observed a large open bottle of vodka along with a baseball bat to be located inside the car. The ignition was intact with keys attached. Mr. Nieves began sweating and stating he did not feel well. He proceeded to vomit on the sidewalk. It was determined that Mr. Nieves would be transported at that time to the Holy Family Hospital for evaluation. Mr. Lantigua was advised of his Miranda rights. Mr. Lantigua was given his rights again back at the station. They noticed that his eyes to be bloodshot and glassy. They detected a slight odor of alcoholic beverage emanating from his breath. The trooper then traveled to Holy Family Hospital in Methuen. Mr. Nieves was determined to have minor injuries. He was advised again of his rights of Miranda. He stated that the vodka was already in the vehicle and it was being consumed by all parties. He was asked why he was driving, to which he informed the officer that Mr. Lantigua had asked him when they were leaving the house party if he wanted to drive, and he said yes. Would be noted that that was the first individual that the officers noted operating. He also indicated that the third party's name was J-Rock, and that's all he knew him as of. Judge, the Commonwealth's request for the bail on Mr. Lantigua and Mr. Nieves go to the facts of the case. These two individuals were not stopping for police. It was their intention to not respond to any orders of authority. They are a flight risk, not only out of New Hampshire, but now in Mass, and their charges that they face here to ensure their return. I'm asking for the $5,000 on Mr. Lantigua, as well as the $15,000 on Mr. Nieves. He also is wanted out of New Hampshire on a fugitive case, confirming his inability to appear in court.
Okay.
And sorry, Judge, and as well, his charges out of New Hampshire stem from reckless conduct, aggravated DWI, disobeying an officer, and receiving stolen property, similar charges before the Massachusetts courts.
Okay, Attorney Castillo.
Yes, Judge, just to repeat, according to the police report, according to Trooper Tracy, it does appear that Mr. Lantigua was operating during the final stages of the pursuit, Judge. He was actually the one that pulled the car over. He was in the driver's seat, but I believe the majority of this incident, he was not the driver, Judge. He wasn't the operator when he pulled the car over. He has no record. He lives here in Lawrence. He's been a resident of the area for 14 years. He lives with his mother and two sisters and his brother. His mother's in court today, Judge. She's in the front seat to the right of the aisle there. He is employed. He works at Sunny Delight as a warehouse man. He's been there for a couple of years. He did obtain a GED recently, Judge. He's 18 years old. Again, Judge, he has no record. There's no indication that he would leave the area. His family is located in Lawrence. He has nowhere else to go. And I can tell the court that $500 was requested at the police station. I believe over the weekend, Mom was not able to come up with the $500. So I would ask for a personal recovery.
What was the swap? The seat swap thing?
During the pursuit, it was at the end of the pursuit, Judge. It looks like from the trooper's report that it occurred on 110. Where Mr. Nieves was originally driving, and then he... Correct. Or it was involved, it hit, the tires blew out, Judge, is what happened. The accident.
Tire strips or whatever.
The tires hit a curb. They tried to deploy those in Salem. I think they were beyond Salem at that time. The tires hit the curb, Both tires blew out, at which point I think the car struck another cruiser during the pursuit and then came to rest.
Attorney Lantigua.
Thank you, Judge. Your Honor, my client, Mr. Nieves, is 18 years old. He lives in Methuen with his parents. They are in the front row here, Judge. His mother, his father, his sister, they're all here to support my client. He's lived in the area, in the jurisdiction of this courthouse his entire life. Went to school here, is currently working, Judge. He is employed with Gillette and has been for some time. Unfortunately, Judge, he has little or no money for bail, and certainly his family, although they're supporting him, the bail request is far beyond what their needs would be. There is, he comes here, Judge, with no record whatsoever, no juvenile record, no adult record, and although he has entries on his juvenile record, everything against him is dismissed. And not only that, Judge, but he also has no defaults on that record. So I think, despite the Commonwealth's assertions that he would not return to court, I think he is in fact proven already on the basis of what we have on the BOP that he does come to court when he's required to do so, and has in fact done that every time he's required to do so.
He has some record in New Hampshire, though?
Judge, apparently he has pending charges up there. Regarding those, Judge, what he tells me is that he would be willing to waive formal recognizance at hearings and go up there. So what I would be requesting, Judge, is that he released on his own recognizance on the matters before us, and be allowed to sign his waivers and go up to New Hampshire, and that way he's essentially making progress on all of his outstanding matters, both here and in the state of New Hampshire.
Regards to our defendant Nieves, the court orders defendant held without bail on the fugitive charge. It does set a bail of $2,500 on the new charges. In regards to defendant Lantigua, the court does impose a bail in the amount of $500 cash.
Thank you, Your Honor.
Next day, counsel.
I'm sorry.
Mr. Nieves was due back on
Yes, thank you, Mr. Clerk.
9/15, looks like.
Yes, 9/15 on a receiving stolen property charge, Judge. He's not certain who his attorney on that case is.
That's Attorney Stetter.
Oh, said. So,
It's on for a motion, so we can pay him in for that date.
oh, it's on for motion. Well, then, Mr. Said is obviously making some, has put in some work on that case, so we'll leave that with him, Judge. And I think Mr. Costello and I can agree on the 29th, on 9/29 on this matter.